ready?
We're ready.
The Barber Board is now in session. Please rise, and while we're standing, we'll have the roll call. From my right,
Donald Collins.
Larry High.
J.B. Loring.
Joe Jones.
Ralph Payne.
Okay, all present and accounted for. Next, we'll have the prayer.
Let us pray. God, in the name of Jesus, we thank you for this day. We thank you for this board. We pray that, Lord, that we'll be able to do your will and your way. Bless everyone that's here. We ask this in the name of Jesus. Amen.
Amen. Now the pledge to our flag.
Pledge
Allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Now, I'm sure you've all had a chance to read your April and May minutes. And if there's any changes, deletions, additions, we'll have a motion for those changes. If not, we'll have a motion for approval or disapproval. We have a motion to accept the minutes as written for April and May. Do we have a second?
A second.
We have a second. All in favor say aye.
Aye.
Any opposed? The ayes have it. Motion carried. Next on the agenda is the administrative report.
All right. First up, we have seminar extension request. You will find a letter from David Gilbert, and he is requesting an extension from this year's 2013 seminar because he is incarcerated until 2014, and he has provided a letter of explanation for his request on your iPad. I'll let you review that prior to making a decision. After his letter is his licensing information, the year he was licensed, as well as the last instructor seminar he went.
Nature of the offense.
He is just requesting that, I'm not sure. He didn't provide that information.
Instructor's license has always been current.
Yes.
I would be interested in his
I'm going to make a motion to request additional information regarding his offense.
to request additional information as far as the offense.
We have a motion. Do we have a second?
A second.
Any further discussion? If not, all in favor say aye.
Aye.
Any opposed? The ayes have it. Motion carried. Next.
Next, we have a continuing education seminar request. The ladies from Expert East Consulting, who had their first continuing education seminar for both the barber and cosmetology boards on June 8th and 9th, are requesting additional dates. They felt like their first seminar was highly successful. They have a lot of attendees. Both Roxana and myself attended that seminar. We felt like it was fantastic. It was a small group, and everybody was very interactive, and She is requesting additional dates for August the 10th and the 11th, and then again in October the 12th and 13th. She's presenting the same information as previously approved. Just one of these seminars will be offered in Gatlinburg and another in Chattanooga. She's trying to expand the locations where continuing education is offered for ease of the licensees, and we are in big support of that. So.
What's the name of that city?
Chattanooga. It's next to Mayberry.
Yeah. We have a motion. Do we have a second?
Second.
Any further discussion? If not, all in favor say aye.
Aye.
Any opposed? The ayes have it. Motion carried.
One other question, although we have already passed. Now, this seminar will be for cosmetizers and barbers, right?
Yes, that's
okay,
correct.
well, good.
Next on your iPad is consent orders for $750. We just need a motion to approve. Roll through all of their seminar information.
Motion that we approve the consent order of $750.
Okay, we have a motion to approve. Do we have a second?
Second.
We have a second. Any further discussion? If not, all in favor say aye.
Aye.
Any opposed? The ayes have it. Motion carried.
A little bit of miscellaneous before we go on to the legal report, which is next on your iPads. Okay, first and foremost, our PSI contract has been amended. We got the signed amendment just last week. That means PSI will now be able to accept the applications for testing, just like the Cosmetology Board has them accept the applications. It won't be done through the board office. The testing center will do that, which moves the process forward. This was something that was approved probably last fall, but the contract process just takes a very long time to flow through the checks and balances. So basically, we are working with PSI on making a lot of the process electronic. So before they start accepting our applications immediately, we're going to try to work with them on getting an electronic application process where schools can upload their hourly information and all the applicants' information straight to PSI's system. So there is no longer a paper application and paper certification and paper check marks. We're hoping that it will be literally each school have a sign-in where they have a username and password, and that each school goes in and puts each student's information in, an A, a B, a C, a D, name, social, address, phone number, contact information, and then they also put in the student's hours. They check all the boxes for the student. Then the student can immediately set up to schedule their test with PSI. The school will be sent information that all of the application has been entered and processed, and PSI has received it upon hitting the, enter button on PSI's information systems. And the student can then schedule their test. When they go to take the test, a sheet will be printed. Looks a little bit like our PSI score sheet. It'll look like this. And they'll sign off saying that, yes, this is all the answers to their questions, and yes, what the school entered for their information is correct. And when they pass, this will be their pass sheet. So essentially, this will be what we receive from them as their application when they go to pay. Now, this is still in the building phase for PSI, so everybody will still maintain processing the same way, but it's really, really going to speed up the testing process and the time that students have to wait to schedule their test as well. So,
Will be notified in advance.
yes, there will be webinars that will be held to show schools, to give the schools all of the login information, to show schools how to do it. We will have literally a screen up, and then PSI will be available to come to schools if they need help working the process in.
This is not related to NSA, is it?
No.
The thing on television all the time.
A lot of these small schools, are they going to be able to?
We're hopeful that they'll be able to comply. The board will have to, once PSI has the final form for approval, we'll present that to the board, and the board will vote to approve that form for all schools to complete. And once they do that, it'll basically be, this is our new process, the board's approved this process, and they'll have to maintain compliance.
What will be the other option?
They could send in a paper form, but it's just going to take their students that much longer.
Would a student be able to log in and monitor their own progress?
No. It's security purposes. Each school has their own login because the school's responsible for sending the students' hours in.
The student would not have access to this?
No.
Another question, is this a monthly hours to be posted to PSI?
No, this is your final,
Final grade.
posting for the students who are applying to test.
Okay, that's good. Okay, but then we won't have to make the monthly report to the board?
You will have to make the monthly report because we will be auditing that against what's sent to PSI for security reasons. But we're hopeful that the whole regulatory board's office is in the process of obtaining a new system called CORE. It will replace the regulatory board system, which is our electronic system that holds all our licensing information. And we're hopeful that that system will have a tool to allow schools to upload their monthly hours electronically to our system, where you will no longer have to send in papers. And PSI has also advised that if you have 10 students at once that you're graduating that want to test, that you should be able to upload all their information at once via maybe an Excel document. I'm not sure about the specifics of that yet, but they've advised that mass uploading is possible. So, just moving forward.
Yeah, I'm on your side with that.
So,
It just makes it easier on the schools.
yes. Has anybody received their license with this in it yet? No. All new licenses have this notice in it. What it is it's an option for you to sign up for electronic notification of renewals. It's also an option for you or anyone else in the public to sign up for electronic notifications of any laws or rule changes, fee changes, or any other significant policy changes. You go to the website, and there's a little place where you can click to sign up, and you simply just type in your name and your email and click the boards that you want the information to be sent to you about, and every time something new happens, you'll be sent an email. It is, but it's on the website. If you just go to the website, it says notification options, click here to sign up. So I would tell you all to go to the website, and I can email you the link if you want. Okay. So that's.
I'll have to plug my computer up.
You would have to plug it up
Okay.
if you wanted to get that.
I like that, though.
Okay, one other small question, and this is actually a legal question that Chris and I have discussed. The Barber statute currently says that Master Barber reinstatements exams are only required to take the practical, but we require them to take the law and the practical. And just for Roxana and administrative processing, has that been a policy decision that you all have made in the past, that you want them to take the practical and the law? Because the statute only requires them to take the the practical as a master
Is there
barber.
anything in the rules where
not.
we have had input?
It's just been I guess, a spoken policy.
It's been that way as long as I can remember.
Way back from,
Turn of the century.
yeah.
You
started in
want
the
us to
70s, I think.
maintain them taking the practical and the law for
I think
reinstatement?
so.
Okay.
I
Okay.
think every reciprocity that comes in ought to have to take a law test.
Well, this is
the state.
reinstatements. So if they let their license lapse for more than 3 years, the law says they should only have to take the practical. And policy, and actually the way PSI has always done it, is they have to take the practical and the law.
I'd like to see it stay that way.
Oh, definitely. want to
After
stay
3
that way.
years, many changes can take place.
Did you have a question, Mr. Rath?
Oh, on our last meeting, board meeting, we
had an
granted
individual,
a
right.
young man that he should take only the practical.
Right.
Do that still stand?
It does.
Okay.
And that was a decision made for him, and that's what the law stated at that time, and that's one thing that kind of brought it to my attention was, well, PSI actually says you have to take, per our instructor examination bulletin for reinstatements, you have to take the practical and the law, but since the board had voted he only take the practical, then he only took the
Do
practical.
we have
because
a reason for, I don't remember that case.
he was trying to get his examination requirement waived, but there's no authority for the board to waive that, so the board had to stay
Was a young
with-
man from Chattanooga
Yes.
that had been barbering for 3 years, come up here and lied?
I remember that.
Yeah.
Would there be an opportunity for that person who license had lapsed for 3 years to be able to get the information concerning the laws? Where they
Oh,
can compare
absolutely.
themselves?
And we
Okay.
sent him the bulletin information that showed him everything on the testing because he had requested that because he said it had been so long since he had tested. Okay, off to the legal report.
We better slow down. We're going to get out of here too quick.
I don't have a microphone right near me, so I'm going to try and speak louder and hope that'll work. Oh, thank you, Rachel. We go ahead and do the legal report. There'll be 7 items on the report for consideration, and as we usually do, I'll read through our report, and board members can make notes for any questions they have, and we can address any questions or concerns or potential amendments at the conclusion of the report. Item number 1, this consumer complaint alleges that the respondent shop allowed an individual who is only licensed as a master barber to serve as an instructor in the shop. The file contained insufficient evidence to substantiate this allegation. Recommendation for that complaint is dismissal. Item number 2, the notice of violation alleges that the inspector observed a master barber, also the owner of the respondent shop, servicing a client with a haircut while his license was not displayed at the shop. The inspector also noted that the respondent shop license was expired. The respondent shop license was renewed after the notice of violation was issued. Recommendation, consent order with a $250 civil penalty. Item number 3, notice of violation alleges that the inspector observed the respondent shop had no inspection sheet posted, the washer and dryer was not enclosed, and that a trash can was open. The inspector stated that the respondent shop was previously given a verbal warning for similar violations in 2011, but no notice of violation was issued at that time. In accordance with the board's prior consideration of sanitary issues, recommendation is a consent order with a $500 civil penalty and a follow-up inspection to confirm the sanitary violations noted in the notice of violation have been corrected. Item number 4, the notice of violation alleges that the inspector observed an individual practicing without a master barber license in a respondent shop and one master barber working in the shop with a laminated license. Additionally, the inspector observed numerous sanitary violations, including multiple dirty workstations, multiple barbers practicing with no ultraviolet sanitizers, and unclean floors. When the inspector attempted to issue the notice of violation to the owner of the respondent shop, the owner began shouting at the inspector, refused to sign the notice of violation, left the shop, and the inspector had to call the police in order to complete the inspection. Recommendation is a consent order with a $750 civil penalty. The board is free to revise that upward if it feels necessary. That $750 is the highest civil penalty I've seen so far, but just a recommendation. And also a follow-up inspection to confirm sanitary violations have been corrected. Item number 5, notice of violation alleges that the inspector observed the respondent shop's owner cutting hair while the respondent's shop license and master barber license were both expired. Both licenses were renewed after the notice of violation was issued. Recommendation for a consent order with a $250 civil penalty.
Now, was that penalty paid before the license were renewed?
Well, in this case, the licenses have already been renewed, so it would just be a matter of signing the consent order and paying the civil penalty to account for the time where both licenses were expired. So, I mean, by the time the file made it to my desk, both of the license had already been renewed. So, I mean, that's why the
It's hard to collect, probably.
It may be, and as with any of the other, as with any of these others, if the board feels differently about the recommendations, they're welcome to change them when the time comes. Item number 6, notice of violation alleges that the respondent shop was open for business despite several sanitation violations, including dirty floors and a master barber practicing at the shop without ultraviolet sanitizer for his implements. Recommendation is a consent order with a $500 civil penalty with a follow-up inspection to confirm correction of the sanitary violations. Item number 7, notice of violation alleges that the respondent shop has inadequate lighting and ventilation, that the restroom facilities were out of order at the time of inspection due to insufficient ventilation. Recommendation is a consent order with a $500 civil penalty and a follow-up inspection to confirm correction of the sanitary violations. This concludes the legal report, and I will take questions, and then the board can vote on the report as necessary.
On number 4, you know, when the inspector had to call the police in, that's serious. And I think $750, we got to send a message to this shop owner. I would say $1,000. That's my recommendation.
I agree.
I have a question also, Chris, concerning number 4. When you talk about, when you mention here about laminated license, tell me about that.
Well, it's my understanding that the licenses are not supposed to be laminated. They can be framed,
Right.
but they are not supposed to be laminated. So that was just
So that tells me that it may be counterfeit.
It very well could be, but the inspector didn't note any additional follow-up in terms of examination of the license to see if it were was
serious.
counterfeit. Agreed. With that said, we're kind of restricted to what's in the notice of violation, so when it comes to the allegations that we can actually pursue in a consent order or formal hearing, and so I did mention that because the inspector noted that it was a laminated license, but I've seen other notices before where they said, oh, well, it's a laminated license, and I pulled it apart and looked, and, you know, the numbers were for something, you know, things like that.
Cases like that are happening in Memphis that I'm hearing about. That's serious. I agree with the recommendations that's already been placed from the board.
Any other questions or concerns other than item number 4?
Hello.
Well, I have one, if I may. I'm always thinking about Mr. Lawrence JB's when he always talks about sanitation, and that is critical. And looking at number 7, talks about inadequate lighting and ventilation, but the bathroom facility is out of order. To me, that's critical. I know we're recommending a $500 civil penalty.
Well, Mr. Collins, the reason I put the $500 was because it was in accordance with the board's general practice regarding sanitary violations, with the board feels that the fact that there were no restroom facilities is a more egregious sanitary violation than some other violations. There is discretion to increase the penalty if need be, but that, I figured that I would start with what the board had started with before, and if there need to be any amendments or discussion, then, that could happen right now.
I'm in agreement with that. And again, in Memphis and Shelby County, we have a health department, and we have to purchase a permit from the health department, and they inspect salons, barber and beauty salons. And if something like that was to happen, they inspect it, they immediately want to shut the shop down. Right? So, I mean, those are things that's critical. I agree with your penalty.
I'd like to ask a question about number 1.
Yes, sir.
The complaint alleges that a master barber was serving as an instructor in the shop. What was he, helping someone to cut a haircut or something? You don't really know, do you?
Yeah, to be honest with you, Mr. Payne, it's a little hazy at best as to what exactly the allegations were. I can mention that the file contains some mention that the complainant in this matter has some employment history with the person about which they're lodging the complaint. It seems that the individual who was complained about worked for the complainant for a very short period of time, and that did not end very well. And so, and then right after that comes a complaint alleging that this person was acting as an instructor. We do have a sworn statement from the shop that the person allegedly served as an instructor, not just a master barber, for, saying, I have no idea about this. This is my shop. This didn't happen here. And frankly, that on its best day, this is a he said, she said issue, and I do not believe that there would be a way forward to probably prove this at a formal hearing. I mean, we could maybe, but I try to. One of the purposes of the legal report is to keep in meritorious cases and screen out potentially unmeritorious cases.
Right.
And I kind of feel that this looks like something that's a dispute between the two individuals, that maybe someone is potentially misusing the complaint process to settle a personal score or vendetta. And I don't think that it's the board's business, or should be, to be doing that.
Shop owner has a barber that's gotten in trouble with a haircut. He's going to go back and help him and instruct him in some way to correct the problems. He would be a very little person if he didn't. He wouldn't care too much about his business if he let a bad haircut go out. So I'm like you. I think this is kind of an
All right. Well, if
I
there,
also make a motion that we accept your report.
as amended with the increased civil penalty on number 4 to $1,000. Yes. All right.
Okay, we have a motion to approve. Do we have a second?
I second.
We have a second. Any further discussion? If not, all in favor say aye.
Aye.
Any opposed? The ayes have it. Motion carried.
Next on your iPads, you have a proposed letter to the General Assembly. Chris has presented a draft of the letter relative to the board's request at the April meeting to change the barber technician license to a barber or nail tech license. And if you all can just review this letter as presented on your iPad. And additionally, I think Chris has a comment about a section that may need to be updated or changed.
Just one thing I had noticed, if this is going to go forward and it is ultimately approved, in addition to changing the education requirement, then there would also be probably necessary an amendment to the section of the barber statute which defines the scope of barbering. If this is going to be allowed, then instead of manicuring and nail care, it would need to say something like manicuring, nail care, and pedicure, or just manicuring and pedicuring, some amendatory language to include pedicuring within the scope. So that might be something that that needs to be added to this. But I it didn't occur to me until after I'd already drafted this letter and it was loaded on the iPads. So I did want to bring that to the board's attention in case, somebody else thought of it as well.
And just as a side note on that, when you make these sorts of recommendations to take into consideration any other statutory changes that would need to be made to
Well, we could have some discussion on this situation if you thoughts of a change.
And
in
Mr.
that.
Loring, this letter is actually under your signature.
Noticed all the spelling's correct and everything. No discussion, or do you want to read
Didn't
more?
finish reading it.
Okay.
Okay, this is so that we can have the 600-hour educational requirements. Is that correct? Okay.
And Chris, what did you want to change in the letter?
The only thing that would be added in is it would make very little sense if this were to be taken up and approved ultimately by the General Assembly to make provision for an educational requirement to allow education for pedicuring, but not to expand the scope of barbering to include pedicuring. I mean, both of those things have to go together if this is going to go forward. So it's just one of those things that was really so common sense. I think I kind of overlooked it when I was drafting this, but it occurred to me after this already been loaded on the iPad. So that will be added in. It's really nothing more than a sentence or two change to reflect that. So I just wanted to bring that to the board's attention while this was under consideration.
So if this passed, that would be mandatory for a barber to take pedicuring? Would that be mandatory, or would they have option?
They have an option.
They have an option.
Yeah.
It would be optional. If the barber in question elected to do pedicures, they could pursue this educational course and then do that in addition to their barber duties, their master barber education requirements. But if they elected not to do so, it's not a forced thing. So it would be up to the individual professional.
All schools will not teach that 600-hour program, just like all cosmetology schools don't teach the nail program now.
Another question.
Sure.
With this pedicure class, would it be isolated from the other students? Because what I see, if I'm taking just a regular barber course, 1,500 hours, and the student next to me, he's taking the full course, 2,100 and some hours, I'm learning, although I didn't pay for this, but I'm seeing him and I'm learning. But just by watching him, I think if it could be, I don't know, it seems like it's got to be isolated some kind of way.
This is a basic letter that the board is presenting to the General Assembly to make the legislative changes to the.
Right.
So as far as the details on whether it would be isolated and the inclusions and that sort of thing would likely come later with a rulemaking that the board would authorize and promulgate. Does that make sense?
Got to get it in legislature to get it passed, and then we make the rules after it's passed.
Yes, that's
Right.
correct.
Does it make any difference? It says president here and chairman on the letter.
You are technically the president, so that would be something we would need to change on the letter. I did notice that just as we were
Probably this
sitting.
board's the only one that has a president.
Probably.
I don't know how that got started. It's been that way ever since I can remember. Okay.
We just need a motion to approve. If everybody.
Motion to approve.
Do we have a second?
I second it.
We have a motion, we have a second. Any further discussion? If not, all in favor say aye.
Aye.
Any opposed? The ayes have it, motion carried.
Last but not least on the agenda, we have a notice of appeal for one of our litigation cases, and Mark Green, our litigation counsel, is here to discuss that with you all. I believe he's going to talk about the notice of appeal from a default judgment, and then he's also going to explain the appeal process, because this will be something the board will have to make some decisions on and hear later down the road. So, Mark.
Good morning, gentlemen. I know it's rare that I appear before you. It's good to do that from time to time, and I guess this situation that we have is a case that was heard before the administrative law judge, as is all Barber cases that go before and have a formal hearing. This matter, this gentleman filed a timely appeal seeking to have it heard, or have the matter heard before the board. And so under the rules of, under the statute and the Uniform Administrative Procedures Act, they have the right to do so. That's kind of rare. I don't know if there's been any that you've heard previously, but this gentleman has requested an appeal, and so an initial order has gone down from the administrative law judge. However, that didn't become a final order, because this gentleman wants to have the matter, wants to have the issues presented before the board. So what takes place now is, before we go into the merits or me explaining to you what the case was about or what anything like that, we have to do a scheduling order, meaning we've got to set down a schedule for his side to file a brief that will go before the board, for me to file a response, and for him to have the opportunity to file a reply to my response. And then the board will receive the transcript from the hearing, will receive the briefs as presented by the parties, and then will make the decision on whether or not you want to hear our oral arguments or oral presentation from the parties, meaning the gentleman come here and say, this is why I brought this matter before the board. I want you I'm asking you to first what the administrative law judge did and why, and then my response to that. You don't have to hear oral or arguments. That's up to the board on whether or not they want to. But we need to make a decision today as far as what the scheduling order is going to be. And I will draft that, and I'm going to present to you what I propose we do on that matter, and then let y'all decide whether or not that's satisfactory. Your next board meeting is August the 19th, I believe. Is that correct? And so what we propose is we set a hearing date for August the 19th. And working back from that, the board would schedule his brief be done by July the 5th, meaning in the administrative offices by July the 5th. And then the state's brief in Roxana's office by July the 19th. That's a 2-week lag time after his brief is filed. And then by August 2nd, his response brief or reply brief to our response brief is due. So that would be July the 5th, his brief, July the 19th, our response, and August 2nd, his reply to our response. And then we send everything to you on August the 5th, meaning you get the briefs, you get the transcript, you get the technical record that went with the file, and that gives you until August 19th to review the materials all at once. You don't get pieces of information, you get it all at one time, and then you have a couple weeks, exactly 2 weeks to review that, and then you come before the board and you either make a decision on that day based on a discussion of what you've read, the materials you've read, or you decide we want to hear what everybody has to say. We want to hear the respondent's side and we want to hear the state's response to that. But we've got to determine all that today. So, Mr. President, if you want to entertain a motion or discuss whether that schedule is satisfactory to the board, and also whether or not you're going to want to hear oral presentations from the parties.
Do we have to make that decision now?
Yes, you have to make the decision now for both of those things. First and foremost, just as a side note, everything that Mark has presented for a scheduling order is acceptable generally across the board for any other board, the time amounts and the processes. It just so happens it works out that there is no meeting in July, so this is able to be heard at the next meeting with the time that we have. And some boards want to hear oral arguments. Some boards are fine with just making a decision upon the issue at hand upon review of the documentation. So, but these two are things that you have to vote on this month because they can't be prepared to provide an oral argument next month if you don't go ahead and make this decision at this meeting. So first we would need a motion to approve the scheduling order as presented, and then second, a motion to request or not request oral arguments.
Okay, we have, let's move on the first.
Well, I'll make a motion that we accept the scheduling Mark has presented us.
I second it.
We have a motion and a second. Any further discussion? If not, all in favor of the motion, say aye.
Aye.
Any opposed? No. The ayes have it. Motion carried. Now, we need a motion on the oral arguments. Do we want to hear oral arguments or not? And really, it's a toss in the air. We don't really know anything about it to decide whether we can or can't. But
It's not so much. It's really a preference. Some boards, don't. It really doesn't have any evidentiary weight as far as some boards are comfortable not hearing the oral argument. Some boards want to hear. They want to read, and then they want to hear what the person has to say of what they submitted. So, I mean, it's really a matter of preference.
At that time, we don't even know what's involved, right?
Right.
it would be my opinion that we don't need to hear oral arguments. By the time we read everything, we'll have a good hand. That's my opinion. But we do need a motion, one way or another.
It's not an appeal on the facts of what happened. It's really an appeal onto a legal issue. In this case, so it's likely it's going to be clear cut for you one way or the other. There's not a lot of gray area here, in my opinion, but we can't really get into the details of the case because you have to be presented everything in the for the scheduling order. So if you feel you can't change your mind, meaning on the 19th, if you said no oral arguments now, you can't later request oral arguments. So
Sorry, I just wanted to maybe try to clarify as well. We will be sending you everything that the judge saw. You'll have the entire transcript, so you'll be able to read all the evidence that went in at the hearing. You will have the order and so what you're going to be asked to do is to decide whether there was enough evidence to uphold what the judge did or not. Essentially,
Would the two parties be here if we decide to do it orally? Would the two sides be here?
and one party is Mark as the state. So
they will have the opportunity to be here. Whether they will come or not, we don't know.
Because with me, I could read the material. It may be so much that I could read the material, but personally, I would rather see someone and look in their faces and determine and make a decision that way. That's just me. So,
Okay, we need a motion, and after we get a motion and a second, we can have further discussion.
I'd like to make a motion that they appear before the board.
That they appear before,
They appear before the board, yeah.
do we have a second?
I second it.
We have a motion and a second. Now, further discussion. No further discussion? All in favor of the board appearing before the board, say aye.
Aye.
Any opposed? The ayes have it, motion carried.
Can I just clarify that appear before the board means you want to hear their oral arguments?
Right.
Okay.
Yes,
Right.
yes. Now, we will still get the information sent to us, right?
Yes.
Okay, good.
Yes, you'll get the information, and
That'd be
then,
good.
Good, that'd be
and then
good. Okay.
and then 2 weeks later, you'll hear our oral arguments.
Now, will you be
Maybe.
mailing us a packet of information every so often? Okay.
Well,
Get
it'll
it all
be
at
all
once.
at once.
Oh, all
So
at once.
on
Oh, that's good,
on the
yeah.
5th of August is when we will send it out, so you should probably get it on the 6th or the 7th, everything.
It will be rather, there will be a lot of material in there with the briefs and on top and the record,
fine.
and so, and then it should be self-explanatory, but
I sure hate to ask a question like this, but does all of this come out of our budget?
I believe the paperwork will be a legal budget, and the way legal is paid for is percentaged out per each board, per how much they use. So I don't think it's like you get a big chunk because of this. No. No, I don't think this will make you go in the room.
Okay.
I'm going to go upstairs now. I don't know where you are on the agenda, but I'm going to draft that order hopefully before you're finished, so I can get President Loring to.
Okay, well, we are almost finished. I think Laura wants to speak, but he can come upstairs. We can bring
I'll
him
wait
upstairs.
till you get it
Okay,
done.
all right.
Yeah.
It should be just a few minutes.
I'm retired, so I don't have any questions.
I just want to say one more thing. Okay, sorry. I just want to say one more thing, because you all haven't had, and this is an unusual occurrence, this sort of appeal, but I just want to the Open Meetings Act. When you get the packet of materials, you cannot talk amongst yourselves about anything having to do with the case or the, what you're reading. If you have questions, you're welcome to, I guess, call Rachel or Roxana, but otherwise, you just sort of have to wait until you get here for the meeting, and then you can talk. That will be your opportunity to discuss the case, okay? Thanks.
And what she means by that is on the record for the public to hear, and that's a public meeting. So if you get it, don't call and say, hey, Mr. High, I have a question about this. Do you understand? Call us about that. Don't call each other.
He wouldn't know it.
You're right about that.
Also, I don't think that Mark mentioned, but there will be an administrative law judge sitting with you that day to sort of help guide you through the process of, because you'll have to sort of dictate your order during the meeting to go out, and the judge will be here just to. It won't be the same judge who sat and heard the case originally. So, thanks.
That is all that we have. So,
Rachel, I'd like to apologize for missing last month's meeting, but I was diagnosed with cancer, and I had to go to the cancer doctor. The good part of it is it's curable, caught early enough, and surgery is scheduled for July when we don't have a meeting, so I'll be back in August.
Let me make you feel real good. 16 months ago, I was given 30 days to live and said no kind of treatment would help me at all. I got on a new cancer.
He said it knocked me down for a couple of weeks, and then I'd be back good as new, so.
you are a trooper just for being here.
All right,
Yeah.
all right, all right.
Yeah.
I wouldn't miss it. I wouldn't have missed last month, but it was scheduled beyond me kicking and screaming all the way to the doctor. Kept telling him I had a meeting in Nashville, and he said, I don't care, you're going to be
See,
good.
I can kid about cancer. One excuse is just as good as another.
Yeah.
My favorite is that I went to the doctor yesterday, and he gave me 6 months to live. And I said, Doctor, I can't even get up enough money to pay you in 6 months. He said, all right, I'll give you 6 more.
Okay. Well, guys, if we can get a motion to adjourn, we can
We
close
have
up.
somebody, if you wanted, anybody else, did you want to appear?
No, I'm Jonathan C. from Palm Beach.
Okay, okay.
Okay, if we have no visitors that would like to speak, then I'll entertain a motion for adjournment.
I'd like to make a motion that we adjourn.
Do we have a second?
Second.
We have a motion and a second. All in favor say aye. Aye. Any opposed, ayes have it. And I'm going to wait right here.
And I'm going to set this up here. Okay.
We want all this paperwork back.
Yes, and I'm going to have